Now, we're still in paragraph 1A of Regulation 2.
Yes, we're looking at 2.1a, and I've dealt with most of the categories. I omitted to draw your Lordship's attention to one category, which is quite important given the air concern. And if I could ask your Lordship to go to tab 22 again, and if I could ask your Lordship to go to Article 7 of tab 22. This is a valid residence permit, and you'll see from Article 6 that has to be granted for at least 5 years. And a valid residence permit may not be withdrawn from a worker solely on the ground that he's no longer in employment because of temporary incapacity to work as a result of illness or accident, or involuntary unemployment. And then you can restrict the period of residence when you renew it to 12 months if the person has been unemployed for more than 12 months. But given that Ayer's concern is that there's a problem for people who exercise their rights of residence and then run into temporary difficulties, that is also catered for by Article 7 of 68 through 60, because they too are dealt with. My Lord, in order to assist you, what we'll do overnight is do a table of the 2.1a people and where they are in the regulations, and the same for 2.2.
Yes.
But standing back from...
Well, if you're going to do that, do we need to go through all of these in great detail?
Not in great detail, no. I'm going to stand back and just summarise where we are on 2.1, and then I'm going to give you...
Yes.
I'll give you just 4 categories on 2.2 as a flavour, so your Lordships don't have the impression that this is a narrow as opposed to a very broad thing. So where we are on 2.1 at the moment is we've seen that the conditions deem habitually resident workers and their family members, the temporary unemployed worker and the temporarily incapacitated worker and family members, the retired or permanently incapacitated worker, and by a quirk their family members are dealt with under 2.2, and the self-employed and the temporarily incapacitated and family members. So that's where we are at the moment, a wide range of people, some of whom are economically active, some of whom are no longer economically active, some of whom are socially integrated because they came with their wives or with their husbands or were relatives and so forth. My Lord, turning to Regulation 2.2, and there we have another group, and that's in tab 9. And this is people who have to establish a right to reside and habitual residence.
You say tab 9. This is where we are, isn't it?
Yes, tab 9, 2.2.
Yes.
Moving down to 2.2. United Kingdom nationals will, of course, have a right to reside, but they may or may not be habitually resident. It's more difficult for UK nationals than EU nationals in 2.1a because they have to show a right to reside and habitual residence. So 2.2 covers UK nationals, covers Irish nationals, and I'll give you 4 examples for the moment, my Lord, of right to reside under EU law. And I've put a tab of material on your Lordship's desk and in front of your Ladyship, which starts with a case called Ibrahim. But if I could ask your Lordships to turn to tab 14 and to pick up at the same time the clip of material that I've given to your Lordships and your Ladyship.
I'm not sure.
It's in front of you, my Lord.
Oh, it's there. Right, it's beyond reach of my rather short arm. I'm sorry. There we are.
And if your Lordship could also turn to tab 14.
Yes.
And if your Lordship could turn to Article 12, because I want to deal with the parents of children in education in this country. Article 12 survives after Directive 204/38 because it wasn't repealed. And Article 12 says the children of a national of a member state who is or has been employed in the territory of another member state shall be admitted to the state's general educational courses. And if your Lordships go to the case that I've just handed you up, there's also some directives there, but the case at the beginning, my lord, is Ibrahim, and it's followed again in Tejera. And you'll see from the head note that in the first of these two unrelated cases, the applicant was a Somali national. She entered the United Kingdom in order to join her husband, and her husband was an EU national. And the husband had worked from October 2002 to May 2003, left the country and come back, but he didn't work thereafter, so he'd ceased to work. But the couple, who were also separated, had 4 children, and 2 of them had started at school shortly after the applicant's arrival in the UK. The applicant was never self-sufficient, depended entirely on social assistance, and had no comprehensive sickness insurance cover. And she was refused housing assistance on the grounds that neither she nor her husband had a right of residence. He didn't have a right of residence because he had stopped work, and she was a family member of an EU national, but of course he wasn't working because he'd stopped. And the holding over the page, my lord, 1119, held where a child of a national of a member state who was or had been employed in another member state was in education in the latter state, the child and the parent who was the primary carer of the child could, irrespective of the nationality of the primary carer, claim a right of residence in that state on the sole basis of Article 12 of 1612-68. They didn't have to satisfy the directive conditions, and the right was not conditional on the parent or the child having sufficient resources so as not to become a burden on the social assistance and national health service systems of the host member state, and various other things. And just to pick that up at 2 places in the judgment, if your lordships go to page 1139...
Sorry, could you just read to the end of the holding?
That such a right was not conditional on the parent... Well, shall I let your lordships read to the end of the holding?
Yeah, we got so far down, didn't you?
Yes.
Mr. Lewis, I'm sorry, I'm just not quite following why I'm looking at this. I mean, what is the purpose of all this detail about this particular provision? I mean,
because
I'm just absolutely lost. I mean, what's the point? I mean, what point is it you're trying to make by referring us to these cases, this case?
In order to establish objective justification and to see whether the rules meet a legitimate aim and are proportionate, you need to see the group of people who are affected and the group of people who are not affected. I'm seeking to demonstrate that from 21A and 21B, there is an extremely broad range of economically active people and sufficient social integration, like the people in this case, who have eligibility by means of either 21A or 22. And the group of people who are not going to be able to qualify are those who come to the United Kingdom not to work, but to live off benefits, and without any prior connection with the United Kingdom. That's the point. But in my submission, you need to see the range of people covered by the eligibility rules in order to consider the group of people which is outside it, because it is that group of people and their exclusion that we seek to say is objectively justifiable.
I wasn't sure. I thought this particular chapter was looking at people who could acquire a right to reside.
Yes.
And I thought that was to indicate the breadth of Regulation 2.2.
Yes. And 2.2 will include parents of children in education in this country, the primary carers of children in this country, even though none of the parents are now economically active.
In a way, you're saying these are people not excluded by 2.2.
Yes, exactly.
Yes.
They're people within 2.2.
Yes.
And my submission, my lady, is that when you look at the breadth of people within 2.1 and 2.2, it does 2 things. Firstly, it demonstrates that the test is economic or social integration. Yes. And secondly, the width of the test demonstrates the limit of the scope of the exclusion.
Well, I mean, really, these people get in under 2.1.
Yeah, they do.
No,
Do they not under the first part of 2.1?
I don't believe so.
Yes, they do, because 2.2, that's what I was putting
exactly.
to you. 2.2 excludes certain people from being treated as habitually resident. But you have to be habitually resident, which is what you said. You said they have to be.
Yes.
They have to be both habitually resident and have a right to reside. And all you're trying to say is there are plenty of people in that category, and you were going to give us 4 examples.
Yes.
Yes.
But they're not within 2-1A because they aren't workers.
No, they're not
I
within
wasn't
2-1A.
saying-
They're not.
I was quite careful. Sorry, I'm talking across Lady Hill, but I wasn't looking at 2-1A. I was looking at the first few lines of 2-1.
Yeah.
Because so they're not in that category because they've already got they've got they're resident and they've got a right to reside.
Yes, my lord. The way it works is this. 2-1A are those who are automatically eligible. 2-1-2... 2-2...
2-1 are the requirements.
Yes.
By virtue of the but bit of
Yes.
2-1, certain people automatically qualify.
Exactly.
Whether they are in fact habitually resident or not.
Absolutely.
Other people only qualify if they are habitually resident, but of course they qualify under 2-1, but they have to pass an extra test, which is the 2-2 test.
Yes, they have to have a right to reside and actual habitual residence.
Yes, so they don't qualify under 2-2, they're just not excluded under
very
2-2.
well.
That is what you were saying.
I beg your pardon, then it's just...
Yes.
I see what your ladyship is saying, yes.
No, it may be quite important to get the formulation
Yes.
of the proposition the right way round.
Yes. In a sense, yes, it could be important, because if we're going to start doing a texture and saying because it's 2-2, therefore that's one condition, and because it's 2-1, it's another condition, and I do see that, the entitlement, and I apologise to your ladies, by obtuseness, I see where your ladyship is coming now, I apologise.
Trying to read the regulation.
Yes, I do apologise, my lady.
You had 4 categories. You're going to give us a list.
I'm giving you a list
All
of...
the people who get in one way or another.
Yeah, I'm giving you a list of people who wouldn't be in 2-1A, but who are otherwise eligible because they meet the requirement of habitual residence because they have both the right to reside and are habitually resident.
And you've given us one category.
Which is the parent of a primary carer of a child.
Now, Lady Hill said you're going to give us them all. Are they 4 examples? I write
These are
down
4 examples I'm giving.
So this isn't, you're not saying this is exhaustive,
No.
but you're saying this is...
Thing, certainly.
I'm trying to delicate my balance, my lord, between giving you the range, but not dealing with all the detail. And if I can just very quickly give the 3 other examples of people who qualify because they have a right to reside and are habitually resident. And the first group of people, well, there's the UK nationals. The first group of EU nationals that I've given you as an example are the primary carers of a child in education in this country, whether or not the parent was economically active. They will have a right to reside, and if they're habitually resident, in fact, they will get in. Mm-hmm. The second example that I was going to give you, and it's dealt with by way of Regulation 75/34, which is towards the very end of the tab. If you go to the last but 3 pages of the tab,
Which tab?
Which tab is
the clip that I've handed up just a short while ago, my lord.
So we've got past Ibrahim,
Yes.
and we're now looking at...
The last but 3 pages, your lordship should find Council Directive 75/34. And if your lordships have Council Directive 75/34, if your lordship turns to Article 1 on the next page, it talks about the abolition of restrictions on the right to remain for self-employed, and the important one is Article 2. This is for self-employed. It's the right to remain permanently where they've reached retirement age, or B, where they are permanently incapacitated, and Article 3 are members of the self-employed person's family. So that's a second example of people who are not in 2-1A, but they have a right to reside, they are no longer economically active, and provided they're habitually resident, they will get the benefit. The next example is on the very last sheet of paper in the clip that I handed up after the lunch hour, and that is Council Directive 93/65. And if your Lordship looks at Article 1, Member States shall grant the right of residence to nationals of Member States who pursued an activity as an employee or self-employed person and to members of their families, provided that they are recipients of an invalidity or early retirement pension or old age benefits, provided those are of an amount sufficient to avoid becoming a burden. It says social security, but it means social assistance in the jargon that we've been using. So if you're a retired person, you can choose for the first time to go and live in another member state, and you'll have a right to reside. But you have to have your own resources.
Have to have.
Your own resources, sufficient resources. And the last category of people at the material time that we are dealing with would be those in tab 24. And as I say, these are examples. And this is the general right, not for the people past retirement age with a pension who want to go and retire in another country. This is the general right for people who want to go to another country. And Article 1 of 9364 says they shall grant the right of residence to nationals of member states who do not enjoy this right, provided that they have enough resources to avoid becoming a burden on the social assistance system of the host member state. So those are 4 examples of people who get in under 2.1, not 2.1a, but because they have a right to reside and are habitually resident. And if we stand back, and in response to my Lord Rogers' question, what is the point of all this? The point of this is to show you the sheer range of people through economic integration or social integration who are within the scope of the regulations. Some of whom are more favourably treated than UK nationals because they are automatically deemed to have habitual residence. Others who are in the same position as UK nationals because they must show a right to reside and habitual residence. So that, my Lord, was the conditions. I now turn to the first question.
Could you add those 4 to your list?
Beg pardon?
Could you add those 4 examples of 2.2 to your list?
Yes, we're going to do the list overnight, which will have what I've called the 2.1 and the 2.2 in my mind, and that's led to the confusion. And I apologise again for the confusion. I turn now to the first question that I said arose in this case, which is whether those conditions, the ones that I've just outlined, are directly or indirectly discriminatory. Now, as your Lordship is aware, and in fact in the light of the discussion we've just had, it's reinforced, the real requirement is that a claimant must be in Great Britain. And there are a variety of ways, or a variety of groups of people who will be in Great Britain. And that test, the in Great Britain test, does not expressly or overtly or directly, or what other word you wish to use, discriminated on grounds of nationality. It is not formulated on the basis of nationality. It is in Great Britain, and then you've got rules which flesh out when you are and when you are not in Great Britain. And under those rules, as you have seen, there will be many EU nationals who qualify because they are in Great Britain, and there are very many UK nationals who qualify because they too are in Great Britain. And we say, therefore, the conditions do not give rise to direct discrimination. The appellant contends that the relevant question is that part of Regulation 2.2 which excludes certain EU nationals who don't have a right to reside. They don't get in 2.1a, and they're excluded from 2.1 because they don't have the right to reside.
And this comes about because the regulations which have authority to explain what is meant by in Great Britain introduce a formula which involves deeming people to be here and deeming people not to be here. So that's how it comes about.
Yes. It's the way in which the draftsman went about the exercise.
The way the appellant argues it is to say, well, you've got to look at the specific provision without looking at the whole. Whereas I think your case was look at the whole effect of the entirety.
Yes. My first case is look at the whole effect in its entirety. The test is Great Britain, and as I've said, many EU nationals very many UK nationals were satisfied, and that shows that it's not nationality, it's a test of in Great Britain, it's what I called in the jargon.
That, with respect, I mean, that is sheer assertion, isn't it?
That is my submission, yes.
I hope you're going to back it up with a little bit of analysis, because at the moment, the more often you tell us it's a question of in Great Britain, the more often I wonder whether whoever drafted this document was given explicit instructions to try and hide nationality in as clever a way as he could. And that may be entirely unjustified, but the more often you tell us that it's all geographical, the more doubtful I get about that
Very well, my
proposition.
Lord, if you're against me on that, I will then deal directly with...
I don't say I'm against you, I'm just hoping that you will explain this proposition more than just asserting that it's all a question of being in Great Britain.
In due course, I'll be taking you to Bressel, and I'll be showing you the kind of cumulative conditions that the European Court treated as one. And here, when you're dealing with the kind of considerations under 1.2a, which are questions of whether people are or are not in the territory, they are to be dealt with together. When you get to age, and when you get to income, those are different characteristics. They're to do with a different part of the equation. And I fully accept that one could have debates about what is and is not a separate condition or what is a cumulative condition. And in many ways, it's like so many questions of statutory interpretation, a question of first impression. But we say when you look at 1.2a and 1.5, and you ask what is the purpose of these regulations, we say it is to deal with one aspect of the equation, which people are geographically within the scope of Great Britain, and then you get on to age and you get on to income.
Well, all the time you have to test this against Article 3.1,
Yes.
don't you?
I'm going to get on to that in due course.
And that suggests to me, and maybe I'm making the same point as Lord Walker in a slightly different way, that each time you slice down the test, I'm suggesting to you, you have to apply the provision of Article 3.1 and question whether this is giving rise to equality of treatment or inequality of treatment which is prohibited.
Yes. Two submissions on that. In a moment, I'm going to say, even if you slice it down to right to reside, it is still indirect discrimination. I'm coming on to that. But to deal with the first question, the question of slicing down, it is a question of looking at the domestic legislation, looking at the nature of the requirements, comparing that with the way in which it has been dealt with in relation to other cases by the European Court of Justice. The best example is Bressol. There were physically, linguistically, two bits of the requirement in Bressol. You had to have your principal residence in Belgium, and you had to have a permanent right to reside in Belgium, not unlike the sort of regulations we've got here. And the European Court considered them together because the European Court analysed them as aspects of physical residence, if you like. And in my submission, that is the same here. But I'd rather do that when I deal with Bressel than deal with it now, although I'm quite happy to deal with it now.
Well, let's deal with it in the order you...
I think it's better with the greatest respect.
Yes.
Is your simple point on direct discrimination that because of the way in which the qualifications are, there are many non-UK EU nationals who do qualify and some who don't, and there are many UK nationals who qualify and some who don't?
Yes.
And so how can you possibly say this is direct discrimination on the ground of nationality?
Absolutely. And that's the case, my lady, if you look at it in terms of in Great Britain or if you look at it in terms of right to reside in isolation.
Yes, that's why I think the focus on the device, the drafting device that has been used, is possibly unhelpful, as my Lord was suggesting.
Yes. What I don't want this court to lose sight of, because there's one real issue in this case, which is objective justification, is to look at who is in and who is out of the state pension credit and the other benefits. That's the critical question, with the greatest respect. And that's why it's important not just to look at right to reside when you get to objective justification, because you have to look at everybody who's in and out to see what the rules are and to see what the effect is. We're dealing with direct and indirect. It's almost a sideshow in many ways, but we have to go through that issue first. And I say you start with in Great Britain, because I say that when you look at the nature of the requirement, when you look at the drafting of the Act, when you look at the way that such things have been dealt with in Bressol and other cases, these are all aspects of the residence test, a geographic test, and that's why they should be taken together. If I'm wrong on that, and if I could just have 2 minutes to explain why, if I'm wrong on that, and if you focus solely on the right to reside, if you slice it down, as my Lord Hope suggested, and you looked just at the right to reside, what the appellant says is all UK nationals have a right to reside, EU nationals don't. They have to do something in addition to acquire a right to reside, therefore there is direct discrimination. My submission is a submission that my Lady Hale has just outlined, which is even if you deal with right to reside, you still have some EU nationals who will have a right to reside and will be habitually resident, and you will have UK nationals who will always have the right to reside, and some may not be habitually resident. And in our submission, and in response to my Lord Walker, even if he doubts and distrusts the geographic, and we salami slice down to the right to reside, it is still not direct discrimination for the simple reason that it is a rule not expressed by reference to nationality, it is expressed by reference to something else, right to reside, and that thing, right to reside, is something that all UK nationals have and some EU nationals have, and that is sufficient to make it indirect, not direct discrimination. And I'm going to show you Bressel now, which will make good both of the propositions that I've outlined.
Before you go there, can I just repeat what you were saying? You said that even if you deal with the test of right to reside
in isolation,
there will be, I think you were saying.
Yes, there will be EU nationals who have a right to reside.
It's EU nationals.
There will be some EU nationals who have a right to reside.
And are they the people who are listed in 21A?
For these purposes, they're the people who are outside 2A. They're the parents of carers and the other groups that I showed you.
Yes.
As a minimum.
Yes. So that's the 4 examples.
4 examples.
They have to be habitually resident too.
As well, yes. They have to be both.
So they have to, yes, so they qualify under the basic rules you referred to us, but there's something else they have to do, which is to be habitually resident.
No, UK nationals have to be habitually resident too.
But they have to be as well, so there's common ground on that one.
Yes, it must be indirect discrimination for habitual residents, because that applies to both UK nationals and EU nationals without discrimination. It's the right to reside, my friend says, is the only thing that differentiates between British and other EU nationals. And he is saying all British nationals have the right to reside. EU nationals must do something in addition. They must acquire it. Ergo, he says, there is discrimination between British nationals and other nationals because of nationality. And we say no for the reasons my Lady Hale gave. There will be some EU nationals who meet the right to reside, and all UK nationals will meet the right to reside. And then you move on to actual habitual residence in fact. But the fact that it is not expressed by reference to nationality, it is expressed by reference to a legal concept, right to reside, coupled with the fact that there are all UK nationals and some EU nationals have that legal status, right to reside, makes it indirect, not direct discrimination.
I think yesterday we were given a rather simpler example where it's the literary test.
Yes.
Which I think is, I mean, I hope I got this right, was expressed simply that there's a literary test to be entitled to do something such as vote, let us say, and all white people are assumed to have sufficient literacy to be entitled to vote, but black people have to actually undergo the test.
Yes.
And it was said, well, that's an example of direct discrimination on grounds of race.
You need to look very carefully at paragraph 67 of the appellant's case, and you have to analyse that sentence very carefully.
It's in 67, is it?
It is paragraph 67, yes.
Yes, yes.
A literacy test for voting eligibility which is passed by white people because of their race, but which black people can pass only by sitting an examination, directly discriminates in favour of white people, even though the requirement can be met by some, even many black people. That's a false analogy. If white people didn't have to turn up and take the exam at all, and black people did, yes. But here, all people, UK nationals and EU nationals, have to take the test. They all have to have the right to reside. It is simply that, because of the right to abode in the Immigration Act, UK nationals will satisfy it.
So they have to do 2 things. They have to have the right to reside and to be habitually resident.
Exactly.
And that applies to both sides of the...
Exactly. And the right to reside, viewed in isolation without the habitual residence, is still a test that a UK national has to satisfy. They're not presumed to satisfy it. They have to satisfy it. They have to be UK nationals.
Well, the white person has to turn up at the exam room and be ticked off, you're white, off you go. Is it such a false analogy?
Yes, because the test is looking at, has he shown he's got 10 out of 10? And if you turn up and you say, you're white, therefore I assume you've got 10 out of 10, you're black, take the test and I'll see if you are 10 out of 10, that is different. But we say that the right to reside is different. It is a legal concept which you satisfy in different ways. If you're a United Kingdom national, you will satisfy it because an Act of Parliament has given you that right. If you're an EU national, you will satisfy it because an EU regulation or a directive which has been implemented in the UK has it.
So even if the only test was right to reside and there was nothing about habitual residence at all?
It would still be indirect. And it would be indirect, and I'm going to show you why in just a moment, because it is not expressed by reference to nationality and can be met by some EU nationals and all UK nationals.
Sorry, I interrupted you. Do you say that James and Eastleigh was a case of indirect discrimination?
No, that is a different one. That we would accept as direct
But
discrimination.
it didn't say anything about men and women, it said pensionable age.
Yes, but in the text that it was written against, you knew that only men would be 65 and only women would be 60. There was a complete correlation. You could never be a man with a pensionable age of 60. You could never be a woman with a pensionable age of 65. They were actually
And you can never be a British subject without having the right to reside.
But you can have a right to reside without being a British subject. And that is the question.
So
That's the point, my lord.
So you're pinning yourself on the last two lines of Regulation 2.2, are you? Sorry to ask you to turn it up again, but I mean, it matters a lot how the thing is expressed, but you're saying it's looking to people who do not have a right to reside, and that group includes people who do actually have that right, includes all UK nationals. Yes?
And some EU nationals.
And some EU
Yeah.
nationals.
So not all will be excluded. Not all EU nationals will be excluded. It is not by reference to nationality. It is by reference to a legal concept, right to reside. You have to justify it, and I'll come on to justification in just a moment, and that's why we say the case is about justification. But it's not automatic, because everybody will get A, and some people will get A, therefore there is discrimination between the group A and group B.
It did seem to me that James and Eastleigh was, to me, a clear case of direct discrimination.
For the reasons I've given.
Because the requirement translated exactly into all women in and all men out.
And there could be no people from one who went into another. That's my submission, my lady. Yes.
However, it does raise worry about whether you are looking at the people who are included or the people who are excluded. One's trying to look at this concept of direct discrimination. If there's exact congruence, as there was in James and Eastleigh, there's not a problem. But the argument that you're having to meet is that there's not exact congruence, but there is one favoured group which is defined by reference to nationality. Although the words aren't there, that's what it is. That's the argument you're having to meet. And I'm wondering whether we've got any guidance from the cases about this problem of not a exact congruence between the prohibited characteristic and the rule, but an imbalance of congruence.
Yes, Bressel and Bidar,
Yes.
and I'll take you to Bressel and Bidar now, if I may.
Thank you.
Plainly not the Irish case.
No, we've put the Irish to one side for a moment, follow them though we are. Volume 4, Bressel, and then I'll do Bidar. And I'm going to take it, I'm afraid, at some length, because this is precisely the issue that my Lady Hale raised, is precisely the issue
That's why I was putting it to you. Yes.
that Advocate General Sharpstone raised. If you could go to tab 48. And we'll start with the Advocate General, and that begins at page 568. And you'll see the generic question at the top. Students have wanted to pursue part of their education outside their country of origin throughout a significant part of European history. This reference raises not for the first time the question whether the host state can limit the number of foreign students that may enter its education system. It then sets out the legal framework, as is the case, international law, community law, and then over the page, national law. And this is the point that I was making in response to my Lord Walker. It is assertion, but it's the analysis adopted by the European Court as well. If your Lordship goes to AG 12, the relevant national Belgian law defines who qualifies as a resident student for the purpose of the decree. A resident student for the purpose of this decree is a student who, at the time of his registration in an institution of higher education, proves that his principal residence is in Belgium and that he fulfills one of the following conditions. He has the right to remain permanently in Belgium. Two separate linguistic statements there, and we'll see whether they are treated separately, sliced, as my Lord Hope put it, or whether they are treated cumulatively when we get to the court judgment. But let us just pursue it through the Advocate General at the moment. And you'll see at the bottom of paragraph AG 12, the right to remain permanently within the meaning of paragraph 1.1 means for citizens of another member state of the European Union the right recognised by virtues of Articles 16 and 17 of the Directive, and for citizens of non-member states the right to reside in Belgium by virtue of the relevant Belgian legislation. Then if you look at Article 4, which is on AG 15, that explains broadly what happened. There was a total number of students. If the number of non-registered students exceeded a certain proportion, then you stopped taking non-resident students and you just took Belgian students. And then if you go over the page to AG 19, you'll see the heading, the main proceedings and the questions referred. And the Advocate General, and I'll read everything that, anything my friend wants, but they set out the factual reasons why it was that Belgium had imposed this restriction on non-resident students. And if your Lordship goes to AG 27, on August the 9th, 2006, Mr. Bressol and 43 others brought an action before the Constitutional Court. And then Ms. Chavarot and 18 other people also brought an action. And they challenged the difference in treatment that the decree establishes between residents and non-residents in regard to admission. And the question is at 29, and your Lordship will see the question, are the first paragraph of 12 and Article 18 and so on, to be interpreted, fourth line of the question, as meaning that those provisions preclude an autonomous community in a member state with responsibility for higher education, which is faced with an influx of students, from adopting measures to limit the numbers when it's relying on certain specified reasons to do with public finances and jeopardising the quality of the education. So that was the question that was asked. Does EU law prohibit or preclude the adoption of such requirements? And then over the page, you have some preliminary remarks from the Advocate General. And then at AG 37, she starts to deal with the nature of the discriminatory treatment. And the Advocate General notes that the decree limits the number of first-time enrolments. And this is how the Advocate General analysed it. In order to be considered resident and escape that restriction, a student must satisfy two cumulative conditions set out in Article 1. He must show that his principal residence is in Belgium, and 2, he needs to fulfil one of 8 further conditions. 38. The order for reference makes it clear that because all Belgian nationals enjoy, by virtue of their nationality, a right to remain in Belgium, within the meaning of the first paragraph, they will automatically fulfil the 2 cumulative conditions for being regarded as residents, as long as they have their principal residence in Belgium. Conversely, for any prospective student who is not a Belgian national, the second cumulative condition, permanent residence, right to reside permanently in Belgium, presents a real obstacle. In order to satisfy that conditions, EU citizens who do not have Belgian nationality may claim the right to reside permanently in Belgium only within the limits laid down. And that was said to be the difference, just like the right to reside. On the one hand, all Belgians have the right to reside permanently in Belgium. Non-Belgians have to satisfy the additional conditions in the directive. And then at AG 41 is the reference to the proceedings that the Commission had taken. And at the oral hearing, the Commission didn't pursue indirect discrimination versus direct discrimination, but Ms. Sharpston says, I do not believe that the court can or should avoid the issue. It could not avoid it because it had to answer the questions posed, which is, does community law preclude the restrictions?
Sorry, can I just
Yes?
I mean, she seems to treat it for all the world as if there weren't the other options 2 to 8.
Yes.
Does it matter that there?
Yes.
So even if there hadn't been 2 to 8, you would say the case still falls to be decided and considered in the identical way.
Yes.
Okay.
Then AG 43 makes the point that my Lady Hale was making. That's rather surprising. There's no clear definition of direct discrimination. And then 44 is the classic description, comparable situations must not be treated differently, different situations must not be treated the same. And then the definitions of direct discrimination, she says, are taken from the sex discrimination case and so on. And then in the case of indirect discrimination, further down 45, she says indirect discrimination occurs when an apparently neutral provision, criterion or practice would put persons with a characteristic that may not serve to draw distinctions at a particular disadvantage. And then at 47, she says, the problem lies, in my view, in determining precisely what constitutes an apparently neutral provision. And then she analyses that in the paragraphs that you were taken to yesterday, 49 and onwards. And at 53, AG 53, she says, the analysis of what constitutes direct discrimination can be adapted to suit direct discrimination on any prohibited grounds. Thus, as regards discrimination on grounds of nationality, discrimination can be considered to be direct where the difference in treatment is based on a criterion which is either explicitly that of nationality or necessarily linked to a characteristic indissoluble from nationality. And that's what my friend says. He says it's both. It's not just express nationality, it's indissoluble from nationality, and that, he says, is right to reside because he says it follows from nationality. And then we've seen the rest of the paragraphs, and then you haven't been taken to the rest in any detail. The first cumulative condition, AG 59, the first cumulative condition in the first paragraph is that students have their principal residence in Belgium. AG 60, it is clear that such a condition does not constitute direct discrimination on the basis of nationality. Belgians and non-Belgians alike may establish their principal residence in Belgium. Thus, the category of those satisfying the first cumulative condition does not coincide with the category of Belgian nationals, and that would be true in our analysis of habitual residence, because the same would apply. You'd have to see whether, as a matter of fact, a UK national or an EU national.
You say ours will be a fortiori because some EU nationals, in fact, are held to be habitually resident when, if they were UK nationals, they wouldn't be.
Yes. And then AG 64, the second cumulative condition in the first paragraph of Article 1 of the decree. And this, my Lord Walker, is where the Advocate General did treat them differently. And she said, it seems to me in contrast that the second cumulative condition, the right to reside permanently in Belgium, does constitute direct discrimination. And it's for the reason she gives at 65. All Belgian nationals automatically enjoy the right to remain permanently in Belgium, the first of the 8 possible criteria. No non-Belgians automatically have such a right. Therefore, they must either meet certain additional conditions to acquire such a right, those in the directive, or they've got to meet one of the other criteria. And she said the category of those receiving a certain advantage, those automatically having a right to remain, and thus automatically satisfying the second cumulative condition, coincides exactly with the category of persons distinguished only on the basis of a prohibited classification. All Belgians automatically have right to reside, all UK nationals automatically have a right to reside. EU nationals don't automatically have a right to reside, ergo, the Advocate General says, direct discrimination, and that's what Mr. Cox says. And that is what the Advocate General goes on to say at paragraph 68 onwards.
I mean, is her definitional formulation really AG 55? I
think it's really 56. direct discrimination when the category of those receiving a certain advantage and the category of those suffering a correlative disadvantage coincide exactly.
Well, that's more like the Eastleigh.
Yes, and Eastleigh would fit within that.
Yes.
The problem that we have here is there's
We've
no
got the
exact
imbalance,
coincidence
yes.
because some EU nationals have the right to reside. But she says it doesn't matter because it's the automatic thing that is the exact correlation.
And does DECA fit with the exact correlation?
Yes, only men can be pregnant, my
no
lady.
man can be pregnant,
No.
but then...
No man can ever be pregnant. No man could ever have the pensionable age of a woman in James. Pensionable age and pregnancy is another word for woman.
Maybe 65.
Well, pensionable age
You,
is
you
60.
only get exact congruence in the Eastleigh case if you concentrate on a cohort of human beings between 60 and 65. If you look at the whole range of people, it's an exact parallel.
It's Mr. Lockwood.
An exact parallel.
Yes, yeah.
If you look at the whole range of humankind and ask which males and which females are entitled to free swimming.
And the answer is any woman above 65 and any man above 60.
No, the other way around.
Any woman above 60, any man above 65.
And of course, in most discrimination cases, including James and Eastleigh, what you're doing is comparing the treatment of two otherwise identical people,
Yes.
or otherwise not materially different people. A man and a woman aged 62.
Yes. But the point is there is exact congruence there.
Yeah, but I'm sorry, I'd go on, but I'll stop in a moment. But if you can produce exactly the same result in this situation if you concentrate on the cohort of those who do not have an EU right to reside in the state you're talking about.
Yes. But it wouldn't be an automatic congruence because you've already ruled out those who do have the right. And the Advocate General was able to do that because she firstly took the second cumulative condition as something that should be looked at alone. She sliced it, in my Lord's words. Then she said it's enough for direct discrimination if there's automatic satisfaction for one nationality, Belgian, and there's not automatic satisfaction for another nationality, another EU national. And she said there was direct discrimination. She said that was enough. And that would be what my friend would want to say. And my Lord Roger will remember that was what was argued vigorously at the permission hearing, because that's what Advocate General Sharpston was saying at that stage. She salami sliced it. I'm not criticising her, I'm describing her. She salami sliced it, and then she said, I'm going to treat it differently because there's automatic satisfaction for Belgian nationals. It's not automatic for non-Belgian nationals, and the fact that it's automatic is itself a distinction based on nationality. And therefore, she said, there is direct discrimination. That's what she said. But the court did not follow that. And I'll take you now to the judgment of the court, which starts at 596. And 1 and 2 sets out, and paragraph 596, what the case is about. Again, the legal framework is set out at 3 and 5. And then at paragraph 8 on page 598, the national law is described, and you'll see it there, set out, paragraph 9, the same thing.
The double test.
Yes, and then at paragraph 17, you'll see that they describe the actions in the main proceedings and the reference for a preliminary ruling. And then at 27, under the heading the first and second questions, the court says by its first two questions, which should be examined together, the referring court asks essentially whether EU law precludes legislation of a member state, such as that in issue in the main proceedings, which restricts the number of non-resident students who may enrol for the first time in medical and paramedical courses. So that's what the question was. Does EU law preclude it? They're not just accepting an invitation to look at indirect discrimination, because that's what was raised at the oral hearing. They're answering the questions, does EU law preclude? And of course, in order to know that, you have to analyse it. Then they deal with the competence of member states, and they explain why the EU has competence, or EU law has competence in this matter. And then you get paragraph 40, the heading of the existence of unequal treatment. And I do need to read 7 paragraphs, Your Lordship. It should be recalled that the principle of non-discrimination prohibits not only direct discrimination on grounds of nationality, but also all indirect forms of discrimination, which by the application of other criteria of differentiation lead in fact to the same result. Unless objectively justified and proportionate to the aim pursued, a provision of national law must be regarded as indirectly discriminatory if it is intrinsically liable to affect nationals of other member states more than nationals of the host state, and there is a consequent risk that it will place the former at a particular disadvantage, and then there's an unpronounceable case. And that's the definition of indirect discrimination. Then it turns to the conditions in the present case. In the cases in the main proceedings, the decree of June 16, 2006 provides that unrestricted access to the medical and paramedical courses covered by that decree is available only to resident students. That is, those who satisfy both the requirement that their principal residence be in Belgium and one of the other 8 alternative conditions listed in points 1 to 8. And I say to my Lord Walker, that is why we say Bressol is an example of the kind of cumulative analysis of the geographic conditions that I say is appropriate here. They didn't do what the Advocate General did, of salami slice them. They say these are geographic conditions aimed essentially at residents, and they took them cumulatively, and that in my submission supports my argument that you should look at the in Great Britain as a whole. So that's the first point, look at them cumulatively. 43, the students who do not satisfy those conditions, by contrast, enjoy only restricted access to those institutions, since the total number of those students is in principle limited for each institution for each course to 30%. And once that percentage has been reached, non-resident students are selected with a view to their registration by drawing lots. So there's only 30%, and there's more than 30%. They draw lots to see which gets into the 30%. 44. Thus, the national legislation at issue in the main proceedings creates a difference in treatment between resident and non-resident students. A residence condition such as that required by that legislation, and don't forget that includes the right to reside permanently in Belgium, which is something that favours Belgian students, but can be met by some non-Belgian students. A residence condition such as that required by that legislation is more easily satisfied by Belgian nationals, who more often than not reside in Belgium, than by nationals of other member states, whose residence is generally in a member state other than Belgium. It follows, as the Belgian government moreover admits, that the national legislation at issue in the main proceedings affects, by its very nature, nationals of member states other than Belgium more than Belgian nationals, and that it therefore places the former at a particular disadvantage. And 47, the justification of the unequal treatment. As stated in paragraph 41 of the present judgment, a difference in treatment, such as that put in place by the decree of June 16, 2006, constitutes indirect discrimination on the ground of nationality, which is prohibited unless it is objectively justified.
Well, what is odd about this passage, it seems to me, is the way they begin in paragraph 40 by, as it were, really passing over the direct discrimination examination, because they see an easy target, which is is the indirect discrimination.
No,
so they go straight to that.
They're not doing that.
Are they not?
No. Yeah. My Lord, firstly, there would almost certainly be a different legal argument, because if it was direct discrimination, the normal argument is you can't justify direct discrimination.
Of course.
Subject to the question of
I absolutely understand that.
That's the first point. The second point is, with the greatest respect, my Lord, the European Court, for all its many failings, does not gloss over the questions that are referred by the Constitutional Court in Belgium. It is asked, does EU law preclude this? They need to know why, what EU law precludes it. They need to know, is it direct or indirect? And they analyse it and they tell us specifically. Thirdly... Well,
I'm not sure that really answers my point, really. I mean, of course they can deal with it perfectly well, as they do. Mm-hmm. But the whole of this discussion is a very interesting one. It's directed, as we know in paragraph 41, to indirect discrimination, and they analyse that and so on.
No, my Lord.
But why don't they do as the...
my Lord, in my submission, with a very, very great respect, that is wrong. In 40, they are analysing the legislation, 40 to 46, as they are analysing the legislation and deciding whether it's direct or indirect. And when you get to 47, they then say this is indirect, and there then follows 3 or 4 pages telling the National Court how they can determine whether or not that legislation is or isn't acceptable. If the answer was this is direct, it would have been a very, very different set of pages that followed, and a very, very different issue, the Martina Sala footnote 97. So they are not, with respect, saying this is an easy target. We can deal with this under indirect discrimination. They've said at 23, the question that is asked is, does EU law preclude legislation of a member state such as that an issue? At 40 to 46, they're analysing it. They're looking at it cumulatively, 42, and they're concluding that, looked at cumulatively, it's legislation that's more easily satisfied by Belgians, even though there will be other people who satisfy it. And they say that is the characteristics of indirect discrimination, for the reasons that I've given. It can only mean that.
Sorry, Mr. Lewis, do they anywhere say in terms that this is not direct discrimination, or do we just infer that from the way the matter is approached?
It's the latter. By definition, if you say it's indirect discrimination, it cannot be direct discrimination. If you ask what colour is my tie, and you say my tie is red, you are naturally saying your tie is not blue. And if they say, is this legislation acceptable? And the European Court says, we've analysed it. It puts Belgians in a more favourable position than non-Belgians, and that's indirect discrimination. So it's only acceptable if you read the next 5 pages and check that the tests about indirect discrimination and justification are satisfied. That is what they're doing. They're telling the National Court. The National Court comes to them and says, is this allowed? And the European Court says, well, firstly, it's indirect discrimination, so it may be allowed. And then it tells them how they ought to analyse the test on public expenses and jeopardising public health. But it necessarily follows that they have classified it as indirect discrimination, that it is not direct.
And can you point to any paragraph or sentence in which they explain to us why it isn't direct discrimination?
The closest you get is paragraph 45.
Because that's a proposition that makes sense in indirect discrimination,
But not
doesn't otherwise.
And they've already chosen 42, they're looking at them together.
But your main point is that they wouldn't have answered the first and second questions the way that they did.
Well, they couldn't have, my lady.
if they had
couldn't.
thought that it was direct discrimination.
Exactly.
And I suppose, if I can just follow that thing, if you go back to page 579 and we see how the Advocate General approached it,
Exactly.
it's a totally different approach.
Exactly. And what happens is you have the oral hearing, then you get the Advocate General's opinion, and then you get the court's consideration. They didn't write their judgment not having seen Miss Sharpston's exam paper. They'd seen Miss Sharpston's exam paper, and they answered a different question because they said, oh no, that's not the test.
And they also knew that although the Commission had originally said that it was direct discrimination, they had not so argued when it came to the hearing. We get that from the Advocate General, paragraph 41.
Exactly. But if you ask yourself, what is the purpose of a reference? The answer is to answer a question. What was the question? Is the national law allowed? What is the answer? We've analysed it. It's indirect discrimination. It's allowed if it's justifiable applying these tests. It cannot, if it had been performing any function whatsoever of any use to man or beast, have been leaving in an abstract unanswered question, what's the test for direct discrimination? I don't even have to infer it here, because we know from the question, and we know from the analysis of Advocate General Sharpston, that they were exactly asking or considering the question that my Lady Hale raised. What is it that is direct discrimination? What is indirect discrimination? And the answer they gave was, even if something in fact will be satisfied by all Belgian nationals, right to reside permanently, but can be satisfied by some non-Belgian nationals, what that means is that it puts Belgian nationals in a more favourable position and has to be justified, not that it is direct discrimination.
Well, we don't know, do we, for certain, what their answer would have been if it had been argued that it was direct discrimination and then somebody had tried to justify it.
No, I
We don't know
accept
that,
that.
do we?
If they had found that it was direct discrimination, they would have then had to grapple with the footnote that my Lord Simon Brown drew attention to at 97. If you go to page 591,
Yeah.
the Advocate General, having said It was direct discrimination. It says at 1 to 8, to the best of my knowledge, the court has never held that a measure that discriminates directly on grounds of nationality may be justified. I've indicated earlier why I consider that. And then there's a footnote 97, which deals with Martina Sallers. So that issue would have had to have been addressed if it was direct discrimination.
It wasn't.
It wasn't because it didn't need to, because it wasn't direct discrimination. That is the only meaning of Bressel. There can be no other. And it is a meaning that is not, as my friend says at footnote 18 in his case, because they declined to accept the invitation of the Advocate General to consider direct discrimination. That's what he says. He says, in the oral procedure, they were only arguing about indirect discrimination. With the very greatest respect, that is not plausible. One, because they were answering a question from the Constitutional Court, is this legislation contrary to community law? Two, because they had a very clear, succinct and principled analysis by Advocate General Sharpston as to how it should be approached. And three, they did not approach it in that particular way. They don't do what English and Welsh or Scottish courts do and say, we're overruling you. They are an altogether more civilised bunch. They set out their answer differently. Then they say, this is how it is. And that is what happened.
We don't actually know what was argued at the oral hearing, do we?
Beg your pardon?
I mean, do we?
575, 41.
575.
Only from paragraph 41. Is that what you all referred to? Oh, yes. Well, we know from 41, but that's all. Yes, AG
That's
41.
all, yes.
That's all. Yes, I thought they had something else, but no, it's only that.
No. We don't know. We don't know what the advocates for Ms. Bressel and others argued.
No, no idea at all.
Sorry, my lord.
Not from this document.
Well, so
We've got AG 41. I don't think there's any other.
AG 41 refers to the proceedings, and the proceedings would include the oral hearing before the Court of Justice,
Well, so the Commission did not pursue this line of argument in the present proceedings.
contenting itself as did all other parties.
Oh, as did all other parties, the big
Yes.
part. Yes, okay, very well. Then they did. We know that much. So. But it doesn't matter. So that's Bressel, my lord, and that's why I would use that to support my defence against Lord Walker. The more I assert, the more doubtful I begin, because I say, in fact, if you look at 42, it shows it's cumulative when it's geographic. And in any event, whether it's in Great Britain or right to reside, it's still exactly the same, because right to reside and right to reside permanently in Belgium is exactly the same situation, and the European Court treats it as indirect, not direct. And that's why this is direct. And then if I can just show you
Sorry,
BDAR.
I don't want to hold you back, Mr. Lewis. I know you've got a lot to do, but I'd just like to go back to AG 42, just to be quite sure I see where you are. She says, I will analyse I will explain what I take to be the essential distinction between these two concepts. Now, we don't know what the court thought of that, because they didn't explain their position, but do you accept the analysis so far as it goes?
Her analysis?
Yes.
No.
You don't?
Not at all, because she was not followed by the court. That's the whole point. Her analysis at AG 53 explicitly that of nationality or necessarily linked to a characteristic indissoluble from nationality. And she was saying because everyone has automatically right to reside in Belgium if they're Belgian, but doesn't have it automatically if they're not Belgian, she was saying therefore it's necessarily linked to a characteristic indissoluble from nationality and was direct discrimination. I'm saying that's absolutely wrong, and that's what the court said. So with respect, I don't accept her analysis.
Yeah, but I just wanted to be quite clear that that's your position. Thank you.
It's the reverse. And we now go to a case where Miss Sharpston was not in fact the Advocate General, but she was the counsel, oddly enough, because in BDAR she was counsel for the British government. Not that that matters. But
Leading you, I think.
Yes, I was in it too. Yes, I didn't lose it alone, my lord. I had assistance.
So we're going back in time.
And that's...
Does the British government ever win any of these cases?
Occasionally, there's a ray of hope in Luxembourg. More often, there is sunlit uplands in London. But we don't lose hope. Sometimes, Luxembourg comes good. BDAR is in another volume. I think it's volume 6.
Which volume have you?
And if your lordship wants to have my case open, I deal with BDAR at paragraph 47 of my printed case, just for your Lordship's note. And then it's tab 77. We say BDAR... No, it can't be 6 then, it must be 7. Is it 7?
Yes, it is.
It's tab 7 then.
It's volume 7, tab 77.
Volume 7, tab 77. Yes, tab 77.
And your case, I'm sorry.
Paragraph 47.
Paragraph 47 of the case. And I can do this quickly because I set it out there. If I take your Lordship straight into the judgment begins at page 837, and the relevant provision is under paragraph 17 on page 840, because you had to be settled. Under the Immigration Act 1971, a person is settled in the United Kingdom if he's ordinarily resident there, without being subject to any restriction on the period for which he may remain in the territory. Now, all British nationals are not subject to restriction, because they've all got the right to abode. But whether they're ordinarily resident or not will be a question of fact. Some EU nationals, but not students as it happened, could acquire settled status. And if your Lordship then goes to paragraph 49 on page 844, you'll say, by second question, the National Court seeks to know the criteria which a national court must apply to determine whether conditions granting assistance for maintenance costs are based on objective considerations independent of nationality. For this purpose, it should first be examined whether the legislation issued in the main proceedings distinguishes on the grounds of nationality. So they're actually asking the question, is it in effect direct or indirect? And it says the principle of equal treatment prohibits not only overt discrimination, what we call direct discrimination based on nationality, but also all covert forms of discrimination, which, by applying other distinguishing criteria, lead in fact to the same result. That's what we call indirect. And then at 52, it says, as regards persons not covered by 1612-68, i.e. non-workers, the regulation requires that the person concerned is settled in the United Kingdom for the purpose of national law and also satisfies certain other residence conditions, been there for 3 years. Such requirements, and my lord, the requirement is in paragraph 17, an automatic one for UK nationals not subject to restrictions, and a factual one ordinarily resident. Such requirements risk placing at a disadvantage primarily nationals of other member states. Both the condition requiring an applicant for that assistance to be settled in the United Kingdom and that requiring him to have resided there prior to his studies are likely to be more easily satisfied by UK nationals. Well, my lord, in my submission, that's exactly the same as the right to reside. All British nationals will meet the test of not being subject to restrictions. Some EU nationals might meet the test of not being subject to restrictions, some might not. And they considered that to be indirect discrimination, paragraph 54. Such a difference of treatment can be justified only if it's based on objective considerations. And then they go on over the page to deal with that, and they conclude that it's not right to apply that rule to EU students because they can't get settled status in the UK, paragraph 61, and therefore it can't be a legitimate objective. So we say Bressol is just the clearest and latest in a long line of, in a line of case law, I can't say a long line, but a line of case law about direct and indirect. Even if a requirement, and if you look at the right to reside requirement, is automatically satisfied by all UK nationals and satisfied by some EU nationals, it will be indirect discrimination. You've seen that in Bressol, right to remain permanently in Belgium. You've seen it in BDAR, not subject to restrictions.
Though in fact, the Court of Appeal, although they were unanimously with you, didn't think much of BDAR, did they, in the paragraph 20?
It's the only point I would criticise in their judgment, my lord. They should have been more warm towards BDAR, because BDAR is exactly the same. And the key to BDAR is to see it in the way that your lordship has looked at things. Don't be taken in by seductive descriptions of cumulative conditions. Look at each bit. Not subject to restrictions in the UK can only be satisfied by automatically by UK nationals, have to be satisfied by other EU nationals by doing something else. Is that disguised discrimination? Answer, it's indirect discrimination, not direct.
But in this particular case, the EU people couldn't satisfy it.
Exactly, EU students couldn't satisfy it.
So the English automatically did.
Yeah, and some EU nationals, but not EU national students.
Yeah.
I
That's the point. They couldn't preclude any possibility of a national of another member state obtaining settled status as a student.
Paragraph 61.
Yeah.
To stop students getting it. If somebody had come to work in England and brought their daughter with them, and he'd then been here forever and got indefinite leave to remain, and she had got indefinite leave to remain, and she went off to study, that French girl, now woman of 18, would get it. But if she came as a student at 18, as a student she couldn't get it. So some EU nationals would get it. That's why it's indirect discrimination. It was not objectively justified because students couldn't get it.
That's right. It was disproportionate.
It was exactly, my lady. It was not for legitimate aim or disproportionate, however one wants to put it. But the point is that the analysis is indirect, not justifiable, rather than direct, not capable of justification.
Was direct argued there, do we know?
I should know. I did it until we got to election day. I don't think any of the parties really contended for direct. I think everyone assumed that the natural way of dealing with it was that it was indirect. Because until Advocate Sharpston put the question so poignantly, I think it was just automatically assumed that something that was expressed neutrally and could be met by both, although more easily met, indeed automatically met, by UK nationals, was indirect. And certainly the court did that, and it's possible that this was another episode of amnesia on the part of the court, and they missed that trick. But they couldn't miss it when it came to Bressol, because the one person who was not sleeping in Bressol was Advocate General Sharpston, and she drew attention to the very problem that my Lady Hay drew attention to. And you couldn't nod with Homer after a session with Eleanor Sharpston. You knew what the issue was. You really couldn't, my lady.
Certainly right.
Well, the Court of Appeal were a bit puzzled by the case, I think, weren't they? They said reasons unexplained.
They accepted the submission that I made, but did not accept that BDAR supported them. Since then, we've had the Advocate General and the judgment in Bressol.
Yes.
So they were right.
Yes, I see, yes.
They were right because of Bressol. They were right all along. They were talking prose, but they didn't realise it. To switch metaphors.
Right, that's BDAR.
And that's direct discrimination. That's the first issue. You'll also recollect I said there are three issues in this case.
Yes.
The first is, do the conditions governing entitlement to state pension credit give rise to direct or indirect? The answer is indirect. It is indirect if it is in Great Britain. It is indirect if you slice off right to reside. Because in either case, it is something that UK nationals will satisfy and some EU nationals might satisfy. And then you've got to move on to the real issue in the case, which is of justification. In terms of reference, my lord, this is not a referable point because it is absolutely clear from Bressol what the position is. It could not be clearer. And the real issue in this case is objective justification, whether or not the rules we have are justified. And if your lordships still have Bressol open in front of you, it's in volume 4.
So when you said just now a reference wasn't required, that's on question 1.
Yes.
Yes.
And turning to question 2 on objective justification, that is always a matter for the National Court. You can go and ask the European Court questions for guidance if you're a National Court, but ultimately, if your Lordship goes to paragraph 64 of Bressol, turning now to objective justification.
It's tab 48.
Tab 48, yes, my Lord.
And it's, sorry, the paragraph number.
64 of the judgment on page 605. Well, it's paragraph 63 first. It must be determined whether the legislation at issue in the main proceedings is is appropriate for securing the attainment of that legitimate objective and whether it goes beyond what is necessary to attain it. In that regard, it is ultimately for the national court, which has sole jurisdiction to assess the facts and interpret the national legislation, to determine whether and to what extent such legislation satisfies those conditions. And then it goes on to say the Court of Justice, which is called on to provide answers of use to the national court, not abstract, we'll only deal with half the dance, which is called on to provide answers of use to the national court, may provide guidance based on the documents relating to the main proceedings and on the written and oral observations which have been submitted to it. And then it goes on to say what the national court must do. So when we turn to the real issue in the case, justification, that is a matter for your lordships and your ladyship, unless you feel you need guidance on something from the European Court, and then you can send it off and say, we realise that we have to decide if this is objectively justified, but would you mind giving us guidance on these particular issues? But it is for you in these proceedings to determine whether the regulations are objectively justified or not.
And are you relying on the principle which is set out in paragraph 33 of the Statement of Facts and Issues? Because I think you said that paragraph was inaccurate.
It's not inaccurate in relation to Mrs. Patmalniece, because that is the reason why. But let me give you a full answer, my lord, to the question as to whether or not, or how you determine whether or not this is objectively justified. The justification is set out in the Secretary of State's statement, which is at Appendix 1. It starts at page 55 and is paragraphs 4, 17, 45 and 61, and I'm going to show you them in a moment. That
4,
is
17...
45 and 61. And I'll show you that in a moment. That's the justification which has been advanced throughout these proceedings, and paragraph 33 of the Statement of Facts and Issues was not intended to depart from that, and if it has, then there has been an error. That justification was well understood in the Court of Appeal. It's in paragraph 27, and it's also at paragraphs 46 and 47 of the Court of Appeal. So 10, 27, 46 and 47, and I'll show you those in a moment. And the justification is also set out in paragraph 4, 7 and 54 of our case. And I'll show you all of these in just a moment. Paragraph 33 is certainly correct insofar as it deals with Mrs. Patmalniece in her case, because she's a non-economically active migrant from the European Union. She falls into the justification. But we are not, and we certainly didn't intend to agree a statement of facts that said this is aimed at EU migrants. For a start, the rules apply outside the EU as well as within the EU. It was not meant to be a comprehensive statement. And we are not saying there, this is the justification. We want to have a rule about EU migrants. The justification is, as I've said and set out a number of times, where there is economic and social integration, then those with that economic and social integration, habitual residents or deemed habitual residents, are eligible. Where people are coming to the United Kingdom not to work, but to live off benefits, with no previous social integration in the United Kingdom, the aim is to prevent the exploitation of welfare benefits by that group of people. And that is based on considerations of economic and social integration which apply to all nationals, UK, EU, and the world outside. It will have the effect that some UK nationals will not qualify because they won't be habitually resident. It will have the consequence that many EU nationals will qualify because they are economic migrants, they are the widow or widowers of an economic migrant, they are retired or are ill, they are parents of children, and so on. And that's why I was taking my law to all of those, to show you that there's a whole category of EU people who qualify. And whilst it was certainly prompted by concern about the scale of possible immigration from the accession 8, Poland and the East European and Central European states, and the scale is what triggered the review, what the United Kingdom did was, looking at the scale of the problem, They drew up rules that we say were objectively justifiable because they said it is legitimate to claim benefits if you are economically integrated or socially integrated into the United Kingdom. But it is not legitimate to come to the United Kingdom, not to work, but to live off benefits. And that's what the justification is. So it's a rather long way of saying paragraph 33 is fine so far as it goes when you're talking about Mrs. Patmalniece, but it isn't fine if it is seen as a full, comprehensive and entire description of the rule. And could I, in the 10 minutes available, start with the statement of the Secretary of State, so you can see what the objective, what the purpose of it is. And that is in the appendix at page 55. Well, and this is the statement by the Secretary of State for Work and Pensions in accordance with the relevant statutory provisions. I'll read anything my friends want, but you can go straight to the introduction, paragraph 4. The underlying purpose of the regulations is to safeguard the UK's social security system from exploitation by people who wish to come to the UK not to work, but to live off benefits. At the same time, the regulations will allow those who come here generally to work to have access to income-related benefits. Over the page at 13...
7?
over the page at 7, under the heading 6, the government has expressed concern. The government has been concerned for some time about the potential for abuse of the UK's benefit system. Abuse takes many forms: unlawful fraud, lawful expectation. In fact, it's not just by people from abroad, people who have always lived in the UK. The government's concern about those from abroad relates not only to nationals of the succeeding states, but also to people moving from the current EU member states. Hence our recent signing of the Memorandum of Understanding. So it's not just an A8 thing, it's wider than that, it's all of the EU. It is against this background that works have been underway for some time on how best to reinforce controls. As the committee has acknowledged, difficult and complex area. Government has been seeking a viable solution which we meet the main objectives and steer a middle way between meeting the financial needs of people who might find themselves in this country without other means of support and protecting the UK taxpayer from a potentially limitless financial burden.
Sorry, which you just read?
8 on page 56.
Yeah.
9, the accession of the new member states is given added urgency. It is the prompt, but it is not the purpose. And then going on to 13, that explains the habitual residence test, as it used to be, without the right to reside. And 4 lines down in 13, the purpose was to prevent benefit tourism by people with little or no connection with the UK, such as students who visited the UK for short periods, funded their stay by claiming income-related benefits. Then at 14, I'll read anything my friend wants, the government believes that the habitual residence test serves a useful purpose to the limited extent of discouraging benefit tourism among people from abroad who have no intention of looking for work or taking up work or of remaining here. But it cannot and was never intended to restrict longer-term access to the income-related benefits payable out of general taxation among people who, for various reasons, may decide to live indefinitely in the UK without being economically active. And then it deals with 15, and it deals with what they thought the position was, but they were told by the House of Lords it is wrong. And then 17, the government believes that it is not unreasonable to expect that, whatever their nationality, people should show they have a right to reside in the UK before being entitled to benefits funded by the UK taxpayer. Indeed, correspondence that I and my ministerial colleagues have received suggests that the public generally expects this. The proposed regulations are thus intended to fill a gap in measures to safeguard the public purse against exploitation by people with no right to reside here, irrespective of nationality. And he knew that British nationals would get it because he says so in the memorandum that predated this. Their purpose is therefore different from the more limited purpose of the habitual residence test. And then they deal with the figures. And then if your lordships go to 45...
Would you read 43 first?
Well, 43, as the committee notes, access to benefits is already controlled for third country nationals In essence, only those with the right to reside in the UK are entitled to claim the income-related benefits. The committee's concern principally revolves around other EA nationals, and in particular those who are economically inactive. There'll be transitional provisions. 45. As already explained, the government considers that it is not unreasonable to concentrate benefits on people who have a particularly close connection with the UK, or to expect people to have a right to reside in the UK before they become entitled to income-related benefits funded by the taxpayer. The EC directives governing the right of those who are economically inactive to reside have been in place, and these are the ones I showed you, since the early 1990s. And then they explain what those are. That EA nationals who are economically inactive, for example, retired people, had to have sufficient resources to avoid their becoming a burden on our social assistance in order to be entitled to reside, and so on. So that's the purpose, and then you see the conclusion at 59. It starts at
58?
50, well, compatibility with EU law starts at 56. 57, the government believes its proposal is compatible with EU law. There's a derogation from Article 8 and so on. 58, Section 8. 58, moreover, the new requirements to have a right to reside in the UK as a condition of access to income-related benefits will apply to UK nationals as well as current EEA nationals. 60, for the reasons already explained, the government cannot predict the numbers of people, if any, who might seek to exploit the availability of income-related benefits in the UK, but we cannot ignore the potential for abuse. In bringing forward these proposals, we recognise there are limitations to the effectiveness of the habitual residence test. In general, the test serves to prevent immediate exploitation of the income-related benefits by new arrivals in the UK, but its effectiveness is limited to a few months at most. Many people can become habitually resident within 3 to 6 months of arrival, and sometimes much sooner. Provided claimants are habitually residents, there is nothing at present to prevent those from other EU states, current as well as new, from claiming income-related benefits without having a right to reside. The government has been concerned for some time that some current EEA nationals have taken advantage of free movement to become an unreasonable burden on our system, even though this negates their right of residence in the UK. We believe that it is reasonable to expect people to have a right to reside in the UK before they can have access to the income-related benefits, particularly as support may last for many years. These proposals should bring the UK more into line with a broad approach of policy and practice. So that was the purpose. Those coming to the UK not to work, but to live off benefits, and that would be compatible, in the view of the government, with EU law. My friend has suggested at various stages that we didn't realise that UK nationals would all have the right to reside, but if you look at page 88, the memorandum, which was the first part of this, and if you look at paragraph 13, it says UK nationals, top of page 88, will need to be able to show that they have a right to reside. They have a right of abode under the Immigration Act, and they'll have to show their passport or birth certificate to prove it. But the point is that these rules were designed to strike the balance between ensuring that those who are economically active or sufficiently integrated did continue to be eligible for benefits, but those who came not to work, but to live off benefits, and not with any sufficient integration into the state, would not be eligible, because that was exploiting the public purse and putting the public purse at undue risk.
Yeah.
And that was the purpose, which is my very long answer to your question about paragraph 33.
Yes.
I'm now going to turn to the Court of Appeal.
Well, I think we'll
Or
have
tomorrow.
to reserve that tomorrow morning at 10:30. Thank you very much.